Hello, and thanks everyone for joining us for our webinar on how to participate in the review of federal environmental assessment processes. I'm Alexis Stoimanoff, and I'll be moderating today's webinar. Today's webinar is meant to provide you with information and tools to participate in the federal government's ongoing review of environmental assessment processes. Our expert panelists are going to explain what's going on in the review and how you can get involved, and they'll also be going through some of the key solutions and recommendations to address some of the most pressing issues faced in federal environmental assessment today. Now, to briefly introduce our panelists, Anna Johnston is staff counsel here at West Coast Environmental Law. She is the co-chair of the National Environmental Planning and Assessment Caucus and a delegate on the Multi-Stakeholder Advisory Committee appointed by the Minister of Environment and Climate Change to help the expert panel with its review. Anna helped organize and write the outcomes of the Federal Environmental Assessment Reform Summit that was held in Ottawa last May. Byron Williams is the director of the Public Interest Law Centre in Winnipeg, Manitoba, which has represented First Nation interveners in major energy proceedings. The centre has worked closely with elders and traditional land users to assist in the presentation of their Indigenous worldviews in environmental decision-making and with First Nations organizations on consultation and accommodation issues. Byron teaches poverty and law at University of Winnipeg and is a regular presenter at the University of Manitoba Faculty of Law on matters relating to administrative law and rights-based advocacy. And our third panelist today is Dr. Justina Ray, President and Senior Scientist at Wildlife Conservation Society Canada. She's been appointed to numerous government advisory panels related to policy development for species at risk and land use planning in Ontario and Canada, and she's the co-chair of the Terrestrial Mammal Subcommittee of the Committee on the Status of Endangered Wildlife in Canada, also known as CEAA. So now, without further ado, I will hand things over to Anna to get us started.
Great, thanks very much, Alexis. So my name is Anna Johnston, and I'm going to begin just by giving an overview of the Federal Environmental Assessment Review process, talk about the panel members, the different types of engagement, and some of the questions that they're asking to help you prepare your participation in the review. So just to begin, this slide is a representation for me of why we need federal environmental assessment reform in Canada. It's a map of cumulative impacts in northeastern BC. If you take all of the seismic lines, the roads, the transmission lines, the mines, the well sites, and you draw them in red, and then you draw a red 500-meter buffer zone around them, which is the area of impact that scientists agree is, the area at which you can, around an impact zone where you can expect wildlife to be impacted, then this is what northeastern BC looks like. So we've had environmental assessment in Canada for decades, and clearly it hasn't been working well. So lucky for us, we now have an opportunity to participate in an environmental assessment review that is public, is open, and has a very broad and potentially visionary scope. This is a quote from the Minister of Environment and Climate Change at the Federal EA Reform Summit that Alexis mentioned. She talked about this opportunity as an opportunity to enact a legacy law. So I just want to mention that as a framing to keep in mind when you're preparing your submissions, that the government and this review panel really are keeping an open mind to all of the possibilities, and they are open. We do have the potential right now, the opportunity right now, to move into the next generation of environmental assessment law. So it's a pretty exciting time. So in September, an expert review panel began the review of federal environmental assessment processes. It has 4 members. I'll go into detail about them in a minute. They have a very broad terms of reference, and in fact, there was a public comment period on the draft terms of reference, and some groups commented that the terms of reference had what could be construed as narrow scope in some ways. For example, the draft terms of reference talked about what the purpose of federal EA is, and a number of groups and people commented that the panel should be tasked with looking at what the purpose of EA is and not be directed to keep its review within the scope of what we already think it is. And we saw an amendment in the final terms of reference that acknowledged that. We saw a few other amendments too that really made sure that the sky is the limit in this review. So with that broad terms of reference, the panel began its public and Indigenous engagement in mid-September. It's doing a cross-Canada traveling roadshow until mid-December, ending in Nanaimo in British Columbia, and it will be accepting public comments, written comments, until December 23rd. Its report and recommendations are due on January 31st, 2017. The panel is going to give those to the Minister of Environment and Climate Change, who will take them and consider them along with her colleagues in Cabinet with the outcomes of the other federal environmental law reviews that are going on, the Fisheries Act, Navigation Protection Act, and if it ever gets launched, the National Energy Board Act. So who is the panel? The chair is Joanne Gelina. She was the Commissioner of Environment and Sustainable Development under the Auditor General for a number of years, up until about 2007. She also was on the Quebec BAP, which is a consultation, environmental consultation and engagement body. She's quite smart, very driven. She's a get-her-done type. She probably will very much like the idea of this being a legacy law. The four panelists, my guess from meeting her and doing a little bit of background checking on her is that she'll be quite open to visionary reforms. Rod Northey was or is still a lawyer at Gowlings, a major law firm based out of Toronto. He's up in one of those high-level buildings downtown. He's been working on Canadian environmental assessment since the early days of the first Act. He wrote the textbook on the original Canadian Environmental Assessment Act. He's represented groups on either side of the environmental coin, so both proponents and the public. He was also a member for a long time of the Environmental Planning and Assessment Caucus. He gets most of the issues that are being advanced by the leading thinkers on environmental assessment. He does have some outstanding questions, for example, around the feasibility of sustainability. Renee Pelletier is also a lawyer. She's an Aboriginal lawyer at a firm in Toronto. She is Maliseet from New Brunswick, and so she's going to really understand the issues around nation to nation, Indigenous rights, and implementing the United Nations Declaration on the Rights of Indigenous Peoples. Doug Horswell is from British Columbia. He, back in the late 80s, early 90s, was a provincial NDP politician. He was the Deputy Minister of Energy and Deputy Minister of Finance for a while, and then he went on to become the Vice President of Sustainability at Teck Resources. So he's got that industry perspective. He's retired now and is viewing this as an opportunity for him to get more deeply engaged in areas of interest to him. And then, of course, the rest of the backup to the panel. So they have a secretariat that's comprised of, I'd guess, around 20 people. They're appointed from the Canadian Environmental Assessment Agency and the Canadian Nuclear Safety Commission. They mostly are a very good bunch of working very hard to try to give as much assistance to the panel as they can. They're the ones who get your emails when you ask questions or submit comments. And they're the ones that you'll see when you go to the sessions and sign in or try to register. They also will be helping hold the pen on the panel report. We've heard that the Secretariat is going to be working with the panel to develop the report and recommendations. So, if you get the chance, talk to them. They'll be around the rooms listening to submissions. It's really important that they also hear and understand what you'd like the panel to hear and understand. And then there's the Multi-Interest Advisory Committee that Alexis mentioned. So It's a body that was appointed by the Minister of Environment and Climate Change to help the panel in this review. It's comprised of 6 environmental reps. I'm one of those reps. 6 industry reps and 6 Indigenous reps who are selected from the 3 national Indigenous organizations. It also has a member of the National Energy Board, the CNSC, and the Canadian Environmental Assessment Agency on it. And the agency is the chair. So we meet approximately every 3 weeks to work over questions that the panel has given us and try to come to consensus on key recommendations that we can make to the panel to help them in this review. And then, of course, the public and Indigenous people are crucial in this review. We are a huge part of the reason why we have gotten this review to begin with. The Prime Minister has mandated the Minister of Environment and Climate Change with restoring public trust in environmental assessment processes and entering into a nation-to-nation relationship with Indigenous peoples and implementing the United Nations Declaration on the Rights of Indigenous Peoples is part of the expert panel's terms of reference. It's part of their mandate. And so we have a critical role to play in making sure that they get it right, and they're live to that. The panel is very much looking to the public and to Indigenous peoples to help them put together a good set of recommendations to present to the Minister. And so a little bit about the engagement process. These are just a couple of questions that came from the panel at the sessions in Edmonton. They were the second set of sessions really early on in the consultation process on EA reform. I just am putting this up to let people know the extent to which this review panel understands the breadth of possibility that's open to them. So they're exploring not just going back to the former Canadian Environmental Assessment Act and not just tweaking at the edges of the current Canadian Environmental Assessment Act 2012, but they're also considering moving towards a next generation of environmental assessment, of recommending the enactment of a visionary new law, which is great news because a lot of thinking has been done in the 30 years since the original Canadian Environmental Assessment Act has been enacted, and we know that we can do better. So what the public engagement opportunities are they're divided into 2 broad categories. There's public engagement and then there's Indigenous engagement. For public engagement, you can present, you can make presentations, or you can attend workshops if you want to engage in person. For presentations, you have 10 minutes to present plus 5 minutes for questions. I know that on the panel review website they still say 10 minutes to present, but they did make the decision right at the very beginning to actually allow 15 minutes. I strongly encourage you to take advantage of those 5 minutes for questions. It's incredibly helpful, both for the panel to be able to ask questions to clarify and to better understand where you're coming from, and then to make sure that they understand various implementation recommendations. It also helps you understand what's still missing, what's still outstanding in their minds. You can use PowerPoint and visual aids. If you submit these in advance, they'll be up on the screen waiting for you when it's your time to present. You can also, if you make submissions, written submissions ahead of time, it's very likely that the panel will have read them already. They're doing their best to stay on top of submissions that are made, and that helps them ask better questions when it's your turn up at the mic. There may be options to phone in. They've said that they'll try to do that. So if you can't make one of the sessions, you can't travel to a community where the sessions are being held, then get in touch with the Secretariat and see what they can do to try to phone you in. The workshops or the evening public sessions, they're a little bit different, a little more informal, more a facilitation style. They begin with some information out from the Secretariat, maybe a panel member, or a facilitator. They hire facilitators to help. And then you break into roundtable discussions. There are 2 of these roundtables. They're about 30 minutes long each, and in each of the sessions, the tables are to work through 3 questions. There's also room for you to identify additional questions if you'd like to address them. Somebody takes notes, and at the end of the 30 minutes, each of the tables presents back to the big group what their discussion points have been. The Secretariat takes notes, and at the end of the workshop, the written notes are collected so that the panel and the Secretariat can consider them. And the panel is rotating among the tables during this time so that they can listen into the conversation, ask questions, and just be there and hear the discussions. There also may be a chance at the mic at the very end. That's time dependent. In the session that I was in, we ran out of time, but in case anybody has any issues that they didn't get heard during the workshop, you may have an opportunity to put those before the panel. And then for the Indigenous engagement sessions, the public or the in-person sessions, the presentations follow the same format. The panel may be more relaxed with time. In a lot of communities, there haven't been the Indigenous presentation slots haven't all been filled, and so the panel has allowed Indigenous presenters to go over time. In some communities, they've been very relaxed with time, more so I found than with the public presentations. And then in the evening, on the days of in-person Indigenous engagement, they have open dialogue sessions. These are informal circle discussions where participants and the panel and the Secretariat sit around a circle and just discuss what issues the Indigenous participants would like to discuss. It's relatively unformatted. The panel members may ask questions, they may just sit and listen. It depends on their reading of the room. And then in addition to the discussions, they have written questions around the room on posters with sticky notes and felt pens, so you can provide your thoughts in writing if that's an easier way to engage. And I should note that the public is welcome to participate in either the Indigenous presentation sessions or the Indigenous open dialogue sessions. And in fact, because Indigenous participation has been relatively low in a lot of communities, the panel has been phoning people up who've been on the wait list for the public sessions and asking them if they'd mind switching over to the Indigenous days, just because there are these unused time slots. So if you'd like to participate in a presentation and the public sessions are full, look to the Indigenous sessions and apply to those, because in many cases there are a number of slots still open. And then of course you can submit your comments in writing online. So there's no page limit, there's no format. This is a really informal process. You can submit as many documents as you want, as many times as you want. As I said, it would be a good idea to give something in writing to the panel before you present to them in person, to give them an idea of what you want to discuss and to allow them to ask good questions. There's also a choice book that they have online. It's a questionnaire on various aspects of federal environmental assessment. It takes about 30 minutes to fill out. Some people that I've spoken to have found it a helpful guide to give them ideas about what they might want to talk about and recommendations on specific aspects of federal EA. And then there's also the option for webinars, which is an option that the panel has put on their website and has discussed. To my knowledge, there haven't been any to date, but it's another option for people participating in remote communities, or if you have an issue-specific proposal that you'd like to talk about and enough people that it warrants discussion for, I'd recommend reaching out to the panel. For example, if you wanted to discuss in a more concise way what a climate test in environmental assessment would look like, the panel might organize a webinar to deal with those topical issues. And just a few notes on developing your message. The panel really is looking for concrete recommendations for reform. So this is what Rod Northey asked one of the presenters in the Edmonton sessions. He asked, ask yourself or tell us, how would I approach environmental assessment if I were starting from a fresh slate? So what they're looking for is specific examples of problems and solutions. So Rod recommended that you frame your presentation or your recommendations in these 4 key points. First, what's the problem? What isn't working? You don't need to spend a lot of time on this. It's why we're in this environmental assessment review in the first place. So it's generally understood that most people think that federal environmental assessment is broken, and that especially that CEAA 2012 isn't working. So go into what would be a better approach and what exactly does that approach look like. If you can get into concrete details of how a better system for doing things would look, that's what the panel really wants to hear. It's not always possible. Sometimes you have to stay up in that principle level, but if you can get down into details, great. And then they're asking at all the sessions, do you have any examples? Are there examples from other environmental assessment processes, from other decision-making processes, from other jurisdictions that you can give? It will help them when they're providing recommendations to the minister if they're able to say, look, this isn't totally scary stuff. We've done this before. It's a safe zone. We know that this is a better way of doing things. Oh, and on that note, that's all for me for now, so I'm going to pass it off to our next presenter, Byron.
Thank you, Anna. And Anna spoke at the very start about the ambitions of the federal minister to create a legacy law, and obviously the CEAA panel review is also in the context of a broader dialogue relating to the nation-to-nation relationship, and the vision of reconciliation is articulated by the Truth and Reconciliation Commission. But like other systems, Canadian environmental decision-making has struggled in that objective and that process. And what I'm going to offer are some preliminary and very exploratory thoughts. I hasten to add that these are ones that are unique, not unique to me, but they are not necessarily reflective of the perspectives of my clients in their entirety. Here we go. There's 4 underlying messages of this presentation. The first, in terms of Indigenous laws and worldviews that regarding the environment, is that they've existed for thousands of years. They certainly predated contact, but Western laws have driven Canadian resource management and environmental decision-making since Confederation, and obviously before Confederation. While Indigenous laws and worldviews continue to exist and be very vibrant in some locations, Canadian environmental decision-making has often sought to squeeze Indigenous people into Western rules and processes. And when Anna spoke of starting with a fresh slate, one of the messages I'm going to try and offer is an opportunity to try and restore balance in environmental decision making and to recognize Indigenous laws and worldviews must be placed on an equal footing with Western laws. And we're just moving to another slide. So in terms of my objectives, clearly Canadians rejected the prior federal government's path in 2015, so what next? And what I hope to do is identify one legislative and one regulatory or assessment effort to create greater space for Indigenous worldviews within Western processes and laws, and then highlight a perspective that seeks to have Indigenous worldviews and laws recognized on an equal footing with Western traditions and legal traditions. And in essence, that flows from some of the work we have done in assisting Cree, Anishinaabe, and Dakota elders in capturing their laws in writing and in teaching about their laws to others, including regulators, youth, and newcomers. And I hasten to add that we've played a very modest role. The elders are driving the bus of that process, and I am indeed an imperfect messenger in the sense that I clearly come from a Western worldview. So what is just in terms of an interesting legislative example that may have some lessons for CEAA 2012 in terms of integrating Indigenous worldviews, I think that there's been some interesting work in the Northwest Territories. Obviously, there's some unique aspects to that. The regulatory regime flowed from land claim agreements and negotiations between the federal government and First Nations, and is really captured in an intriguing piece of legislation, the Mackenzie Valley Resource Management Act, as well as some of the Territorial Waters Acts. And some of the interesting aspects of the Northwest Territories approach include a co-management system between government and Indigenous groups, which is really, in my view, radically different from many of the models you'll see in other parts of Canada, including agreements to compensate First Nations for damages or losses prior to the issuance of a license, and express recognition of the need to integrate Western and traditional knowledge. And certainly in the reference to cumulative effects monitoring in the Mackenzie Valley legislation, there's an explicit reference to the integration of Western scientific knowledge and traditional knowledge, and an obligation on the boards to consider the importance of conservation to the well-being and the way of life of Aboriginal people. Again, reference to traditional knowledge and scientific knowledge. And water is an issue that's of particular importance to many of my clients, and express protection for Aboriginal water rights, including the use of traditional heritage, cultural, and spiritual purposes. So that's a legislative example of an attempt to integrate, to at least some degree, Indigenous worldviews into Western laws. And I want to turn to an example, an interesting example from an environmental assessment. And in 2014 in Manitoba, we had the Kiosk environmental assessment. Kiosk is a $7 billion hydroelectric generating station on the Nelson River system, a river system that has been highly compromised by prior industrial development, including hydro development. And in this project, it is actually a so-called partnership agreement between 3 Cree Nations and Manitoba Hydro. And I put the words partnership, there's a contract. The First Nations are entitled to own a certain percentage of the station. So there are some economic resource sharing elements as well as planning sharing elements. Clearly, there's a partner with all the money and all the resources, and 3 partners with much of the knowledge, but also inherited environmental damages through the other partners. So I'm not suggesting it's an equal partnership. But one of the intriguing aspects of this environmental assessment is that there was actually parallel assessment tracks with 3 of the First Nations conducting their own assessments of the project based on their Cree worldview and 50 years of hard-won experience with hydroelectric development. So that was based upon Cree worldviews. And in the other track, the partnership, including the Cree Nations and hydro, provided the more traditional Western type of assessment that I think we're generally more used to. The underlying principle in the assessment of the project was to be that the technical science and Aboriginal traditional knowledge would be employed and given equal weight. And before we leave this slide, I'll just comment, as someone who comes primarily from a Western perspective, or exclusively from a Western perspective, this process for me personally was revelatory in that the quality of 2 of the Cree Nation assessments was so far superior to that of the Western assessment. It caused me to rethink my entire professional vocation. But still within that process, major concerns arose, and there were conflicts between the Cree worldview and the Western worldview. And I think an opinion held by many is that when there was a conflict, the default position was that of the Western technical science. And on this next slide, I share with you a comment actually prepared by one of the panelists for the Manitoba Clean Environment Commission in terms of this process, Mr. Reg Nepanak. And he talks about the argument that the Cree worldview is equal to Western science, but notes, and this is a panel member, that the robustness of the Cree worldview was not properly acknowledged, noting in the second bullet that there was a unique worldview and governance structure unlike the Western model, and it was dismissed, and much the same way as the Indigenous worldview is dismissed today. So I think this is an intriguing environmental assessment, one that holds a lot of learnings, but ultimately has been subject to significant criticism in the sense that when one tries to meld or integrate Indigenous worldviews into Western legal processes, the default position often is the Western legal process. So the question in terms of making appropriate space for Indigenous worldviews, giving real weight, goes back to that power relationship. And I talked about Kiesk as a partnership, but clearly not all was equal between the partners. And we have to ask if that power relationship is not equalized, how profound are the changes that we have undergone? I wish I could claim credit for this diagram. I can't. This is by Aaron Mills, a brilliant scholar and Anishinaabe person currently at the University of Victoria. And he observes that in the context, while we have made efforts in terms of reconciliation in environmental law, he worries that they're made at an incomplete level, that we're getting a sense of the leaves, but not the branches, the trunk, or the roots, that there is a deeper understanding of Indigenous worldviews and legal traditions that is necessary before we're going to fully benefit and fully engage and begin that path of reconciliation. And again, just a couple of analytic notes. If we think of Western environmental law, we often think about managing natural resources. If we think of Indigenous legal traditions, environmental legal traditions, or worldviews, we talk about relationships with the water, the land, the fish, the rocks, the animals, with newcomers, with each other. Profoundly different. And those are the roots, the branches, and the trunk that we don't often consider. And certainly as someone who's just beginning to be exposed to these traditions, from a Western perspective, we often starkly segregate process from substance. The elders have assisted me to understand that their process, their worldview is much more holistic, and that the ceremonies that I used to regard as kind of curiosities and sadly perhaps as entertainment are powerful, profound, and intimately integrated into the deliberative process, and that, you know, the roots, the stories that they tell through those ceremonies are how they develop their constitution, their laws, and that there's more learnings from those than I have begun to appreciate. So here we have just a focus by and a reminder by both Mr. Mills as well as Diana Kwan, who's a senior Justice Canada legal counsel, that you can't develop a relationship in the midst of an assessment. You can't develop a relationship exclusively through the prism of Western laws or legal systems. As Mr. Mills, soon to be Dr. Mills, points out, before you can learn about Indigenous people, you have to learn how to learn. You have to be in a relationship with us. And Ms. Kwan points out of the need to change from regulation to relationships. At Turtle Lodge last year in Sagin First Nation in Manitoba, a group of Cree, Anishinaabe, and Dakota elders started to capture in written words the legal traditions and the worldviews that they've held since time immemorial. And they call it the Great Binding Law. And I just put it out as an example of Indigenous environmental law. That last year was shared with the National Energy Board, with federal and provincial politicians and industry leaders. And it was shared in ceremony, and it was shared at Turtle Lodge on traditional grounds in a traditional setting where the pipe ceremonies, the water ceremonies, the songs were part of it. Far beyond ceremony, there was substance as well. And without going into great detail, it's an interesting examination of who we are in relationship with, an observation, not surprising, that the relationship is highly damaged, and that the first stage of restoring balance from the elders' perspective was to learn how to learn, to come to their lodges and to show some humility in the face of a profound and thoughtful and long-enduring legal perspective that has a lot to offer. So the question I ask in terms of our presentation is, as we look at this federal environmental assessment and the legacy that we're trying to achieve, dare we go to the lodges to listen and hear? Dare we recognize both systems of law as equal? As part of this legacy dialogue, dare we talk about enabling appropriate processes for environmental decisions for both systems, and talk about how they relate to one another in practice? There's a great quote that I heard this weekend about making space for me to exist as me in your space. It was offered by Tanya Kappel, and really was, I think, going to the point of making the point that the discussion of environmental law is really part of a broader dialogue about reconciliation. And a key question is, can we achieve reconciliation or move on the path to reconciliation simply by making space within Western legal traditions, or by recognizing Indigenous legal traditions on an equal footing? And I'll simply note, and here's some free advertising, that the elders are offering another event at Saugeen in late November. The Premier of Manitoba will be attending, some federal leaders, and it's sharing their knowledge and with youth and with newcomers and others. And I thank you for the time, and I'm going to turn you over to Justina. We're turning this over to Justina. I'm not sure if you can still hear us or not.
Sorry about that, guys. I think we might be having a little audio issue with Justina.
Oh, shoot. I've been on mute this whole time.
There you are.
That's terrible. I was worried that was exactly what was going to happen to me when I put myself on mute. Okay, so everybody saw my first slide, and I'm going to start right now on the second one. Thank you very much to Byron and to the West Coast Environmental Law for Center for inviting me to this webinar. Prior to 2015, our concerns about the role of science in environmental policy were very different from what we're dialoguing about today. They were really about whether or not science is going to have a role, and whether it was going to be a meaningful role, and whether decision-making would be based on available evidence and science and indigenous science. And that changed rather swiftly last year, in the sense that immediately the tone about science changed rather radically, both solving the issue of, presumably solving the issue of what was widely known as muzzling, but also widespread pledges, beginning with mandate letters, to include science very deliberately in decision-making processes around the environment. And indeed, this renewed commitment to decision-making has been also focused on EA reform. And so the mandate letter, of course, from the Minister to the Minister of Environment and Climate Change to review the EA processes were to ensure decisions were based on science, facts, and evidence. Also, the stated goal of the federal EA review, when it was announced, said immediately incorporating scientific evidence and was going to be a key feature of this review process. And then that extended to the actual terms of reference of the EA expert review panel, of which we've been speaking. That again, taking directly from the mandate, how would decisions be ensured to base on science, and what would be the role of science and indigenous knowledge, which I should have also bolded there, in environmental assessment. So obviously it's a source of key preoccupation in this review. Having said that, it's it's easy to say you're going to do it, but how to do it is a different matter, and how and what barriers there might be to ensure EA decisions have a strong scientific basis. It's actually not so simple, and there are actually at present quite a number of barriers, and so it has been important to spend some time analyzing this within the context of a very, very complex process that aspires to do many things and in its decision making. And indeed, when you look at this, and what I'll be making a case for today in the brief time I have is that these changes would want to be reflected in the legislation itself, in policy and guidance that may emanate from it, and then also in practice, which relates both to how things are done, the process by which environmental assessments are conducted, and these are lengthy processes individually from start to finish, but also the very culture of the practice as well. That there are some issues that would require sort of a sea change in order to meet the aspirations from this scientific perspective. In terms of looking at this topic, I mean, I think it's very interesting already off the bat just to look at the legislation itself and the role that science writ large plays in this. And if you look at it carefully, the word science or scientific is not mentioned even once. So no bit of that word is ever in the Act at all. But then, okay, so knowledge, expert information, that's mentioned in 5 sections. So for example, somebody with knowledge is included in the definition of an interested party. The federal authority's obligation in terms of its role and the expertise that it should have is also mentioned in a couple of sections. Aboriginal traditional knowledge is mentioned once, related to factors to be considered. So it's not really about knowledge of impact. It's really about more what the scoping of the EA should be about. And then there are some aspects about knowledge of impacts, but not necessarily scientific, in the TOR of joint review panels. And Aboriginal knowledge, traditional knowledge, or any rendition of that is mentioned only once in the entire Act in Section 19, in the way that I just described. And in the couple of directives and published policy guidance that follow legislation, they really stick very closely to what the law has said with respect to science, so they don't go any further than the legislation, and that's notable as well. So in summary, there is some very limited focus in CEAA 2012 on the role of science with respect to particular roles of entities that are involved, but only the federal authority really in this vein, and nothing about process or products. And so, okay, is that normal? Well, the interesting thing is to compare this with another act that I have a lot of familiarity with, which is Species at Risk Act. And although it came into force a decade prior to CEAA 2012, it provides a really interesting contrasting example. So the word science is mentioned 7 times in the Act. Knowledge, information, science, etc. is mentioned in 12 different sections, including, notably, the preamble and the purpose of the Act with respect to roles, products, and process. So many different dimensions of it, and it permeates the Act throughout. Aboriginal traditional knowledge is mentioned 8 times. And policy and guidance, although it's been extremely limited, has reinforced this role of science in the various documents. But more notably for the case of Species at Risk Act, there have been several court decisions in the decade of its use that have really reinforced this issue about the separation of science and socioeconomic decision making in particular areas, and have really reinforced this aspect. And so CEAA really does explicitly distinguish between all these dimensions of the Act that consider scientific information, including Indigenous science alone, and those that include socioeconomic considerations. And this is really quite notable in terms of process. But so if we go back to CEAA, I mean, is this because it's not needed? Well, absolutely not. If you look at the big, messy process and very long time, and this is from one of the graphics that is available on the CEAA website, science is required at every stage. It's required in the scoping, it's required in the review, it's required in the generation of the EIS guidelines, which are effectively the terms of reference, and the review of that, and then all these analyses, the decision itself, and then notably in follow-up enforcement because of monitoring. And so it's everywhere. And so it means that the notion of science in all its forms really has to be robust in these processes in order to figure into the decision making, which is the desire. And there's a useful sort of analysis that is important to see about all the different actors. And so if you look at federal and provincial agencies, where they are involved now and where they could be involved even more is the development of the guidelines, the review of the product, the A report itself following the review of the environmental impact assessment. So this is quite a significant role. Then the proponent, through consulting agencies usually who deliver on the science, are into their neck with project description, at the very beginning, the environmental impact statement, all of the baseline data that come from that, the monitoring, etc. So that's a huge role. The joint review panel has a big role and has to have some scientific dimensions in it as well. And then finally, there's the whole outside acting force of government, that are not necessarily involved in the EA themselves, but are nonetheless quite involved in generating information that's relevant for EAs, academic NGO scientists, indigenous communities, etc., that all are relevant. They all produce work that is relevant. The extent, however, to which they're involved in these things has been mostly rather disappointing. And Greg and Dunker a few years ago wrote a very helpful paper upon which I've drawn, looking at sort of the distinction between these inside actors and those outside of the process, and the fact that there was really very little coordination between them, and so that the outside players who have so much to contribute in terms of the quality of science and knowledge that is relevant for environmental assessment are not involved in this process to any way, and there's a lot of reasons why, which I won't be able to get into, but they advocated quite convincingly for really much more coordination and deliberate coordination and integration between these inside and outside players. And so just to end this presentation, I'm just going to kind of tempt you with some big major issues that require attention, and to better ensure that these EA processes and decisions are based on the best available science. I'm developing a paper on this so that these ideas will be fleshed out more, but they relate to a whole host of issues on this. And so first, as you saw, the legislation itself could be clearly, more clearly distinguish and have language about the incorporation of science and knowledge in the EA roles, products, and processes, similar in character to what I presented and showed for the Species at Risk Act, and then having a preamble and a purpose, for example, that would also reinforce the role of science from the all the way up to decision making would be helpful. But the development of the EA products need a lot of work and guidance, and many of you will probably know why, but they relate to both the quality of the work, the scientific quality, and also the fact that a lot of them are very large or not necessarily entirely relevant. And so there needs to be a lot more attention to developing guidelines on expectations of the scientific quality, which can have various dimensions, and that could better ensure meaningful and relevant information for decision making. The review of the products is very, very important. Right now, it's very inside and not necessarily transparent, and there's not a whole lot always the capacity that's required for this, and the huge role that the federal government has on this score. And they solicit reviews mostly through passive public participation process, and so there needs to be much more attention to soliciting reviews and even analyses by outside parties who have very relevant expertise to bear on these, and also increase resources for Indigenous peoples as interveners to bring their knowledge into the review process. The decisions need to be guided by much better decision-making criteria, but also for what to do about reporting and interpreting uncertainty. And finally, monitoring and adaptive management is absolutely huge. And this ranges from investing in regional monitoring programs that happen mostly outside of the direct EA process, but also for the actual assessments themselves, demanding a robust design, clarifying divisions of responsibilities, ensuring sustained oversight, reviews, etc. That can be there's a lot of improvement in those areas, and particularly for the purposes of coordinating between projects and learning from experience, and that is very critical. So that's all I have to say for now, and I'll turn it over to Anna Johnston again, who's going to talk about the 12 pillars, and I thank you for your attention.
Great, thanks very much, Justina. And I'm sorry if I was fading in and out when I was presenting earlier. I'll try to lean a little more close to my computer. So as Alexis and I referred to a little bit earlier on, back in May, West Coast Environmental Law organized a Federal Environmental Assessment Reform Summit. We had about 30 of Canada's leading experts from across the country come and discuss key issues facing federal environmental assessment and try to come to consensus on key reforms in light of this EA review. So the outcomes of those discussions have been distilled into these 12 pillars of the next generation environmental assessment process. I'm not going to go into every one of these pillars, but I would like to really briefly touch on a couple of key ones. I'm trying to be mindful of time. I'd like to leave a lot of room for questions. So I'm just going to talk about public participation, which we're calling participation for the people, and then talk a little bit about what a climate test looks like in next generation federal environmental assessment. So one of the key principles regarding public participation that came out of the summit was that it's early, it's ongoing, it's accessible, and it's dynamic. It has to occur at all levels of environmental assessment, and it has to have the ability to influence outcomes. So we've been doing public participation in environmental assessment for a long time, and we're not doing it right. We weren't doing it right before the CEAA 2012 got enacted, and CEAA 2012 made things worse. So, as that earlier quote noted, public participation has to occur early on before proposals are even submitted. It has to be ongoing throughout all stages of the assessment and follow-up. It has to be accessible and dynamic. It needs to be deliberative, not just information out to a decision maker and then put into a black box. Occurring at all levels of assessment means that we should be engaging the public not just on the environmental assessments of projects and activities, but also regionally and in strategic environmental assessments. Right now we have a cabinet directive, a policy document that requires environmental assessments of government policies, plans, and programs, but there's no public participation opportunities in those. They just occur in the confines of cabinet when they occur at all, which the Auditor General has been finding again and again isn't actually occurring. And then, of course, public participation must have the ability to influence outcomes. We shouldn't just be speaking at a mute decision maker. We need to know that our engagement in environmental assessments actually can be influential. And then related to that, public participation has to be based on mutual respect. It shouldn't just be a box to check, an obligation to fulfill, but needs to be viewed as a real opportunity for proponents and decision makers to glean the wisdom and the insight of participants. So what does that look like on the ground? As I mentioned before, early means that participation opportunities have to occur before proposals are submitted. So right now, usually over the course of an environmental assessment, the first public consultation period will begin after the proponent has put down often quite lengthy, very detailed proposals of where they want to develop their project or activity. We need to engage the public in the very early design stages before all of that time and money has been put into designing a project that might be incredibly flawed. And then all the way through the assessment, the public should be brought back in all of the design stages. It's deliberative, which means it needs to be a back and forth. And then, of course, there's a role for the public in monitoring and follow-up and compliance and enforcement, so it shouldn't just end before the review body writes its report and recommendations and a decision is made. The public really needs to be engaged all the way through to decommissioning and follow-up. Also, the public should be engaged in the design of alternative engagement processes. So rather than just having town halls and hearings, the public should be consulted on how they'd like to be consulted. That's critical. Different communities will have different needs. Different issues will have different requirements. Sometimes we need hearings so that lawyers can cross-examine. Sometimes we need more user-friendly, deliberative, back-and-forth fora for meaningful dialogue. And then, as I mentioned earlier, we need to engage the public in those other levels of environmental assessment, up at the strategic level and in regional assessments. So, over landscape scales. The public should be engaged in the consideration of alternatives in environmental assessment. We really need to consider the no alternative, the no project, the status quo. And the public should be engaged in designing what are the different options that are on the table in this review. A pipeline, no pipeline, different routing of a pipeline, different method of providing jobs and energy. That's a crucial area for public engagement. And then, of course, EA needs to have a really broad scope for public interest considerations. Also, for the public to be meaningfully involved, the public has to have knowledge at their fingertips. So there needs to be a searchable, accessible database of all information provided for or relevant to the environmental assessment. Currently, we have the Canadian Environmental Assessment Agency website, which sometimes posts information related to environmental assessments, but not always, and not all of the information. We need to have rules around transparency and accessibility so that the public can fully weigh in and understand all of the issues going forward into the future as well, not just during current reviews, but to be able to draw on past information and past experience and apply that into the future. And then, of course, adequate resources and education. It is very expensive and technical and difficult to participate in environmental assessments. You know, currently the public funding opportunities, when they're available, are grossly lower than what it actually costs to hire experts, to hire lawyers, to meaningfully participate. And also we need to provide people with training and capacity building, let them understand better all the different stages of environmental assessment and the different ways that you can get involved. Finally, around the decision-making, the consideration and decision-making, the public really needs to be able to see how their comments were received, considered, and reflected in decisions. So not just speaking to that decision-maker into the black box and not knowing whether and how any consideration was given to your input. There needs to be a reflection back about how the public's engagement, how their insights, how their concerns have been addressed. This needs to happen through written reasons for decisions. So rather than, as we currently have, this justification process that Cabinet does behind closed doors, there has to be thorough reasons provided in writing to the public for why decision makers came to their conclusions. And then, of course, there needs to be a right of appeal, a clear right of appeal, so that the public is able to challenge decisions that they don't think have followed the right information and their concerns in assessments. So the second area, one of the other key areas that we talked about during this summit was a climate test, and this is really top of mind for a lot of people across the country. How do we assess the climate impacts or otherwise implement a climate test in federal environmental assessment to proposals? You know, it's especially germane in today's context when different energy proposals are on the table, pipelines going across the country. How do we meaningfully understand how those proposals will take us down the path or away from the path towards our Paris commitments? So one major thing that we've learned over the course of attempting to assess climate impacts in environmental assessment is that trying to assess climate effects is very difficult, and especially the significance of climate effects. It's very tough to assign effects globally or nationally or even locally to a particular project or undertaking. And so in order to understand a proposal's contribution to climate, we need to move into the use of climate goals as a proxy for impacts. So the test in a next generation environmental assessment would ask, will this proposal move Canada further down the path to our international commitments on climate change? Will it move us further down the path to decarbonization, or will it move us away from it? So in order to understand that, in order to apply that test, we have to begin with some sort of a carbon plan and carbon budgets. And it should be noted, of course, that government-endorsed budgets are international commitments. Those are a floor. They're not a ceiling. So what does that look like? This infographic lays out the general structure of a climate test. So in environmental assessment, we first need, up at the strategic level, to design pathways to decarbonization by no later than 2050 in accordance with our Paris Agreement commitments. That's done as a strategic environmental assessment with robust Indigenous collaboration and public participation. There are going to be many pathways by which we can get to decarbonization. We need a plan that identifies some of these pathways that we've collectively determined are reasonable. In addition to those pathways, we should be developing provincial, federal, and sectoral carbon plans for each of the regions and for each of the different industry sectors. And then from there, once we have a general framework, a general lay of the land that I should note we'll need to visit on probably 5-year increments, tweak and adjust as we go, then we can finally assess whether or not a specific proposal fits within that plan now and over the long term, over the life of the project. So once those pathways to decarbonization are developed, the project assessed with all of the range of options, the alternatives, including the no alternative, the environmental assessment asks, from among this range of alternatives, what's the best option for getting us down that path to decarbonization and enhancing sustainability? So just on a final note before we go to questions, just some really high-level messages that West Coast has been giving to the panel and throughout this review, that federal EA is broken. The Canadian Environmental Assessment Act 2012 isn't working. The former Canadian Environmental Assessment Act was okay, but we've come a long way in our thinking on it since it was enacted in 1992. Now is the time to implement a next generation environmental assessment regime and to have a fresh start on federal EA. Key points that I encourage you to take away is that next generation environmental assessment is an integrated package of leading edge practices. So those 12 pillars that I pointed to before, and I'll put those back up on the screen in a second, those can't be cherry-picked. Environmental assessment doesn't work as promised when you strengthen one area, but not all the rest of the areas. So it doesn't work when you just put in a good climate test or when you just implement meaningful public participation. We need all of those pillars there for environmental assessment to work. And then the test in environmental assessment should be what's the best option from among this range of alternatives for achieving equitably distributed net benefits for the environment, communities, and the long-term economy. Right now, we have a test in environmental assessment that asks basically, how do we make this project less bad? We need to do better than that. We can do better than that. Our communities and the environment deserve better than that. We have alternatives that we're capable of assessing. We need to put those on the table. And then to ask ourselves, what's the best path forward for communities and for the environment and for the long-term economy? And then from the public participation perspective, and especially this is important in this environmental assessment review, is that for the public to buy into the result, they have to be able to buy into the process, meaning they have to feel like they've been meaningfully heard and integrated into the process. So, on that note, I really encourage you to go forth and to talk to the panel, to submit your comments, and to give them your vision for what a leading edge environmental assessment act should be. Just remember, this is a dialogue. It's a two-way street. It's not overly formal. You can encourage them to think big, and you can submit materials whenever and however often as you'd like. So on that, I think we'll open it up to questions.
Okay, thank you so much, Anna. Just before we launch into the questions, we have a poll that we would love for you guys to complete. So I'm going to launch that now. It should pop up on your screen, and then we'll give you a few minutes to respond as we prepare to get into the questions. Great, so thank you for participating in this. It looks like some people are unsure if they're going to present at or participate in the panel sessions. There's a growing percentage that says, yes, I plan to attend a workshop. And some of you are not planning on participating. We'll give it another minute before we close the poll and get into the questions.
Maybe while we're waiting, I'll just jump in on and talk to that 41% unsure cohort. This is really what what I'm hoping to do is to encourage people to go and talk to the panel. If the reason why you're hesitant to go is because the sessions appear to be full, then there is a wait list, and you can go and attend just as an observer. You don't need to register in advance for that. And in a lot of the sessions that have been occurring across the country, people haven't been showing up, and so people on the wait list have been able to get bumped up to presentation slots. Also, if you're not sure that you have a valuable contribution to make, I assure you, you do. Your perspective, your thoughts, your concerns, those are all things that this panel needs to hear from. As I mentioned earlier on, it was the rollbacks to Canadian environmental assessment legislation. It was the implementation, really undemocratic implementation of CEAA 2012 that brought us here to this review. This government heard the message that the public's voices in environmental decision-making is integral, and that's why this review is being conducted in such an open and public manner. And so this panel really has a lot to take away from folks who are concerned about their ability to have a say in decision-making, their concerns about risks to their communities and the environment, all the spectrum of different issues that people might be facing, I think really need to be heard in this review.
Thanks, Anna. So now let's get back into the questions. So again, if you have questions, feel free to type them into the questions pane, and we'll answer as many as we can in the time we have left. We've got about 15 minutes left for questions. So the first question, and this one is probably best for Anna, is from Raquel. If the sky is the limit, can we make the new review basically do what an environmental Bill of Rights might do?
Yeah, that's a really interesting question. I mean, in some ways we can. An environmental Bill of Rights is the same legislative status as a Canadian Environmental Assessment Act, right? So it's not a constitutional right. It's also the mercy of the legislative whims of government. I view environmental assessment as our main tool for how we make decisions about proposals that affect our health and the environment and communities and society, much as the Bill of Rights protects them. So, embedded in good environmental assessment processes are a public right, a right to participate in reviews that affect them, a right to be heard, a right to reasons for decision. So there are all of these procedural rights that are at play in environmental assessment. I think really importantly too is while we're considering what we want a federal environmental assessment law to look like, we have the opportunity to embed environmental rights into this law. So for example, in the preamble of the next Canadian Environmental Assessment Act, we have the potential to put in there that Canadians have the right to a healthy environment, and that the environment has a right to its own health and ability to fulfill its processes.
Great. Thanks, Anna. So we've got another question here. There's a few questions that have come in about the precautionary principle. So here's one question from Mara Martinez. What is it going to take to implement the precautionary principle? Placing the onus on industry or any other actor to prove beyond reasonable doubt that no damage will be done, that no toxic legacy will be left for future generations. So maybe Justina, would you like to take that one?
Oh, yeah, that's a tough one. So the precautionary principle is actually more about making sure that you don't use uncertainty as an excuse for deferring decisions or and such. And it has been applied fairly rigorously in certain decision-making processes like IUCN red listing and COSEWIC assessments, etc. but it's difficult it's difficult to apply, practically speaking, or to make rules for, but you can get in the culture of doing so. And the question a lot is less about how to apply the precautionary principle and more about what you do in the face of uncertainty. And a lot more guidance needs to be placed on that, because we're never going to have ironclad evidence that something is going to have impacts always. We're never going to have that ironclad evidence, and there's always going to be wiggle room, and those who are interested in taking advantage of that wiggle room in a direction of saying yes to a project are always going to leap on that bit of uncertainty that's there. So really where the emphasis has to be is on guidance on how to both report on uncertainty, which you can do very effectively without subterfuge, and that can make a big difference in decision making. And then actually being transparent about how that degree of uncertainty entered into the equation for final decision making. And that transparency is also a key ingredient of that. And the precautionary principle follows in line with that set of circumstances in my experience.
Excellent. Okay. So we have another question here, one from Cheryl, and this one's for Byron. As more Indigenous peoples share in the prosperity that comes from land development, resource development, and related businesses, how will they be able to maintain their Indigenous perspective and view and continue to stand up for nature and the environment?
Wow. Cheryl, tough one. I think some of the elders that we talk to say that they have a lot of teaching to do, not only for newcomers, but within their own communities. And for example, the event that I spoke about in November is actually hosted by elders with youth, and that is a key part of kind of the continued commitment to those objectives. There's a natural tension in all these decisions. Certainly the elders we've spoken to say they're not against development, but they see things as badly out of whack, generally, badly out of balance, and it's about acknowledging that things have been out of balance and trying to almost take a step back and look at the longer term goals of restoring the relationship. When the relationship is in a better place, then perhaps some of these choices will not be so stark.
Thank you. Okay, I have two questions here from Aaron. One, what countries currently have the best EA practices or are leading the way? Do any of the presenters want to take that one?
It's Anna here. I think the short answer on that one is that no country is currently doing EA really well in the way that we want it to. There are countries and jurisdictions that do parts of it well. New South Wales is an example. But where we should be probably looking to for inspiration on how we can do better EA is from some of the assessments that have been conducted in Canada to date. So, the Berger inquiry, for example, is right now our gold standard for a really robust, meaningful, engaging, sustainability-based environmental assessment. We've done sustainability assessments in Canada a number of times before to varying outcomes. They don't always result in a no for proponents. And so we can look to those practices like Foynes Bay and Lower Churchill, Camas North, to find the practices that have worked for us in the past.
It's Byron here. I'll just add, I concur with Anna's answer. In terms of water governance, we've looked at a number of models, and actually the U.S. at the federal level has done some interesting things, and certainly if you look to regions like the Pacific Northwest and efforts to restore river systems, and also in terms of involving Indigenous perspectives, there's at least some interesting legislative examples out of there.
And I just want to add to that, Justina, that I echo Anna's comment about really focusing on Canadian experience where we have the direct experience, because I've learned the hard way that what can look, when something's reported on paper, it's very difficult to know in the real world what occurred, or what is really good, and or what isn't so good as it seemed. And then often legislation may look good, but the implementation has fallen down for various reasons, or vice versa. And so we do have to pick and choose from various examples that we've experienced ourselves. And probably not one full assessment is gold standard, but there are often dimensions thereof that are instructive.
Okay. Thank you, guys. All right, we have another question here. Here's a question from Vicky. What standards, both national and international, are being used and or considered as part of assessment criteria determination?
Criteria for what? Sorry.
Perhaps Vicky.
Yeah, I think overall that's gonna depend on the issue of that. You wouldn't have a one-size-fits-all for all criteria.
Yeah. So a model that West Coast and a number of other groups and academics are proposing in Canada for decision-making criteria is that the legislation set out the criteria that have to be considered when reviewing bodies and decision makers are considering whether to approve a proposal. So right now we have this significance and justification test in environmental assessment that basically says, will this thing result in significant adverse impacts? Can they be mitigated? And are the residual significant impacts justifiable in the circumstance? So that justification decision goes to cabinet, which gets to make it behind closed doors. And we get decisions like with Site C and with Lower Churchill, where the decision doesn't follow the ultimate recommendations of the reviewing bodies. So that throws a huge amount of trust in the process under the bus. And so as a remedy to that, what has been proposed by academics and developed over the course of years and applied in environmental assessments in Canada are the application of legislated and case-specific decision-making criteria to guide decisions towards that ultimate question of, will this proposal from among the range of options on the table result in the most equitably distributed, best sustainability enhancing outcomes? And then in addition to those criteria, we need to have trade-off rules to deal with those situations where, because life is messy, we don't usually have industrial proposals that result in net benefits for the environment and communities and society. So we need to have these trade-off rules for dealing with what happens when there are trade-offs between the environment and communities and the economy, to make sure that one isn't given greater precedence over the other, to the extent that, for example, we have communities bearing the disproportionate burden of impacts while a select few reaps the benefits.
And Anna said it really well in one of her last couple of slides in terms of the climate change assessment, and in essence, some call it a net contribution to sustainability, and whether it's moving you farther down the path towards a sustainable outcome or not. And I thought she did that really well in her overview of that climate change discussion.
All right. Well, we're coming up on 2:30 right now. Is there anything else that any of the panelists would like to add before we sign off?
Well, it's Anna here. I just really want to say again, thank you everybody for being on this webinar. It's an incredibly exciting time in environmental assessment in Canada. We have this once-in-a-generation opportunity to enact a legacy law, a visionary new way of making decisions about proposals that affect the environment. And it's incredible to see so many people coming out to a webinar on, what is a fairly geeky area, which is environmental assessment law reform. So it's great to see that there's so much interest, and I encourage you all to go out and make submissions and talk to the panel and, and to get involved.
And get in touch with any of us if there's any other follow-up questions or anything of that nature.
And I just want to thank West Coast for their leadership in this. They've been doing a great job, and it's much appreciated all across Canada.
Thanks so much, Byron. And just to remind everybody, we will be sending around a link to the video recording of this webinar after the fact, probably tomorrow, along with the presentation slides and related documents. All right. Well, thank you very much for joining us, everyone. Have a great day.
Thank you.